But 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please.
No.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate.
You are Lawrence Bazil. Good morning, Mr. Bazil. So I see here you've picked up 2 new cases. You've picked up a violation of a protective order or bond condition. You've also picked up a burglar of a habitation. It's alleged that on November 26th of this year, you've picked up these cases. I have no idea what's happened with these cases. Your lawyer's here with you. She's on Zoom. Please don't say anything at this point. I just want to find out what's going on because I don't know. So we're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Witness stated on August 29th, 2024, he and his girlfriend, the complainant, were home when the defendant appeared at the front of the property and told the witness that he wanted to kill him or kick his ass.
Okay, hold on. You're going way too fast. So who's at the home?
So the witness and the complainant are dating.
Got
and
it.
the defendant appeared at the front of the complainant's house.
Okay.
Told the witness that he wanted to kill him or kick his ass. The
Okay.
defendant proceeded to walk towards the front door of the house and enter the home without consent. The defendant then grabbed some keys from inside the house. The witness ran outside of the home and the defendant chased after him. The defendant began to hit the witness several times with fists. The defendant then snatched the witness's cell phone and ran out of the house. Complaining witness has an active 5-year protective order against the defendant that was issued on 12/6/23.
So that 5-year protective order is against the witness.
The complainant. Yeah.
Okay, it's a
The
complainant.
complainant is the girlfriend, and that's the VPO. And then there's also the Burghab, but I mean, it's the same complainant.
The complaint is my mother.
Stop. Don't, please.
Hold on, Mr. Bazil.
I mean, really, just now's not the time. There will be a time, now's not it. So what problem did you have with anything, Ms. Oko? Or did you have?
So, yes, Judge. So he was arrested on a VPO on the 30th. The complainant
30th of
August. On the 30th of August for a VPO violation. So for them, for it's a bit, shall I say, unfair for him to be rearrested on a VPO for the day prior to the day he was arrested for the same VPO.
Well,
He spent 2 weeks in jail.
no, but they're different, right? So read me if you don't mind, the VPO on 8/31.
Yes, Judge. So on 8/30, an officer was dispatched to a suspicious person call at the listed address in Harris County, Texas. The complaining witness had an active protective order stating the defendant could not be within 200 feet of her residence. On that day, defendant was walking on the sidewalk in front of her house, which is less than 50 feet away from the residence in Harris County, Texas. The complainant had a picture of the defendant on the sidewalk across the street from her residence within the 50 feet. Listen to the protective order.
So, and that was on August 31st. 30th. This new case that we have here now, this is from November.
It was filed in November, but it occurred on the 29th. So it's just a
Okay,
late
hold on.
filing. That's kind of the confusion.
I see.
And on the 30th, Judge, the complainant actually went up to the
Okay,
police
so
station.
here's the, I don't understand what really, I mean, okay, so here's what it looks like. The first VPO that we have here was for the August 30th case. So what it essentially looks like is we have 2 VPOs happening one after one day and then another one happening the next day. But it looks like I don't understand why, but
Different filing officers. So, I mean, in the first VPO that he was convicted in, the officer filed it the day after. He filed it on the 31st. For some reason, they sat on it until 11/26.
hey, guys, your camera. Yeah. So this new case happened 8/29 versus the one that he pled to in September happened on 8:30. So
He
this is
pled
like
to-
what she's saying, it's a late filing, and it happened the day before that other VPO. You know what I mean?
So I'm reading the DIMS and it actually, so the mom went the next day to the police station to complain about yesterday. That's what I'm reading on the DIMS. She goes to the police station and she says, hey, he's been to my house. He went to my house yesterday and now he's on the crosswalk. So essentially they, on both of the DIMS, they're adding 2 of these days on the same thing, on the same DIM. So she's complaining 20th and the 30th.
We have a 911 call from the incident on the 30th, and it says the officers were dispatched to the house. So I don't believe it was a walk-in report.
I'm literally looking at it and it says that
I'm
she came
also-
to 1200. The complainant appeared at the Houston Police Department Family Violence Unit located at 1200 Travis, and she stated that her son stated the defendant was her son.
Yeah,
I'm reading it.
that's my mother.
Don't,
Mr.
please.
Bezil, hold
Have
on.
someone on your
That's for the
behalf.
most recent VPO. I'm talking about the original VPO. There's a 911 officers were dispatched. The one on the 30th.
That's what I'm saying. On August 30th, 2024, the complainant appeared at the HPD on 1200 Travis, and she complained about yesterday, the 29th event and the today's event. I don't know if there's a today event, but
So, okay, it may be so, but they're 2 separate offenses, right? Maybe she's complaining about it at the time. She's complaining about 2 different things, right? Because they're happening in successive order. But I guess technically to the filing, and there's still 2 separate incidents that occur. Are you saying you're saying it should just be
So,
one VPO and not 2?
I think I figured it out.
Okay.
Yes, she made a walk-in, officers were originally dispatched. She made a walk-in report. She told the officers that the defendant went over to her home wanting to fight her boyfriend. The complainant stated the defendant left when he found out her boyfriend was not home at the time. That's the VPO, or that's the violation that happened that he pled to, I believe. And then the defendant returned to the home to try to fight the boyfriend. That's when the Burglary and the second VPO happened. So these are 2 separate trips to the house. It's just the filing's messed up.
You need to talk to your lawyer, and then she can.
no,
So-
I'll explain to you, Mr. Bezel. Don't worry about it. So essentially, there are 2 different days, even though they happened the one day after the other. She complained the second day about both of those incidences. That's when the officers went to the house to arrest Mr. Bazil, which I think is confusing because if she's complaining about him coming to the house the next day and they go and arrest him that same day, then it's essentially both VPOs should have been filed at that time. I
think I need
Once
to
again-
call the officer. I'm not prepared to make any, decisions on these cases
Why
right
don't
now.
we do this? Let's roll it to tomorrow. Are you okay with that?
Yes, Judge. I mean,
This gives-
Mr. Bill, he's here on the Burglary anyway, which he has not made bond on, so he's still here.
Well, that's true. So you've got the open felony case regardless. So let's do this. We can roll you to tomorrow. This gives you the opportunity to speak with Ms. Hoko. She can do the research she needs to do. It gives more time also to your lawyer to do any other research that she needs to do, and then we can get together tomorrow. And don't. I know you have to understand that anything you say, they're going to use it against you. I know that you're trying to help, and I've seen so many instances where someone tries and they think that they're helping themselves, and then they end up admitting something they shouldn't say, and it helps makes the case. Okay. So what we'll do is we'll have you put you back in back. I'll have Ms. Oko reach out to you. You guys powwow. We'll bring you back tomorrow, and then we'll see what. Yes, yeah. I'm gonna have her call back over there right now, so you guys can talk. Okay? Yeah. I know that you're itching to talk to her, and we're gonna get you right now. 2 minutes. There will be. We will be. That's what we're here for. We're not here to play.
Visit PC, Your Honor. Have some questions.
Oh, you picked up a new case. I'm sorry. I'm just getting wind of this now. I didn't realize this. He just picked this up.
My client or the person?
Yeah, him. Picked up an interference 2 days ago.
That's what I'd like to revisit.
Yeah, of course. So you are on felony probation for a very serious case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case, specifically an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading. And now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay,
Pursuant to the, I guess,
I understand.
that we literally had one after the
Understand.
other, like a rung on a step ladder. One. After. Yep.
And-
So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may,
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd, 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed what?
located. They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon
But he has an open ag assault somewhere else too?
in Fort Bend County, Judge.
my understanding is it's
And
an
it was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going
Judge, how-
plank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe,
So,
but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're
I understand
and
that.
they're a 0.1 mile away from the location
So
for what?
Well, okay, I get that, but so we have what we have. We've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have,
Okay.
right, Mr. Zenon? There's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
It's the aggravated assault, but Judge, I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes plank like this for them being unable to effectuate an arrest.
And Judge,
You don't think that's an interference?
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it. Because, I mean, there's no better way. Let's read it.
Hold on.
I'll give you, all right. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly, they could have
Okay.
taken a whole myriad of, I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on, you know?
but they didn't
Hit.
They took the one that I do not believe applies here.
Let's read the code.
Okay.
Let's see what the code says. Because, you know, there's multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can, it's 3815.
That's okay, don't worry.
You're right. It could have been like a resisting, you know, but. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. Now, so I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
Okay,
with
so
that.
that the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute, that's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1
It's an
miles
open
away.
felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what or the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like. And that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I mean, that's what they were investigating.
And the witnesses all
They
described
put him,
the
I guess, did they put him under arrest at the time when he said that he was making that threat?
And with being
I mean,
0.11.
did they have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening that he would slap Miss Clark.
And it's at that point they start to put him under
At
arrest?
that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
But
pushing.
remember,
That's
I
a
mean,
resist,
it-
that's not interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate with, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague, if the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
We don't.
Well, I mean, it's,
Okay, well, I mean, but so
I mean,
this
we
is,
don't know. I mean,
okay, I'm just saying.
if he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is,
We also
And
don't
he's-
have the offense report
We
yet,
don't
I
Judge.
have
don't care. I mean, but I think that there's enough, he's under, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
I know, but I don't have the video.
I mean,
I've
I
shared the
think that-
videos with.
Remember-
Right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you are disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I gotta say,
Required 3 times to search me.
can I have a moment to look at the video here? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find,
I mean, because
if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, okay, it looks like they didn't give him a PR bond on this.
Okay, well, then we
The
address it.
bond right now is set at 2,500.
Okay,
Your bond upstairs is set at 5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, and I don't know what we need to do to get your attention, man. In life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you, just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend, Judge, and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set
I mean-
tomorrow, Monday,
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want. Surely. Do you have it?
We have the camera, the body camera.
I just shared.
Okay, so
They shared it, they just shared it with me.
let's roll it to tomorrow. You guys take a look at the video as well, be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Okay, all right, Mrs. Zenon.
Thank you.
See you tomorrow.
See you tomorrow.
I'm not happy with you, Mr. Johnson. You're on bond in this case, and now you've picked up a felony case. The only thing I asked you to do, behave yourself, don't pick up any new cases. And now, Morgan, what has Mr. Johnson picked up?
Unauthorized possession of a catalytic converter.
Wow, what happened? Please.
So officers were dispatched to an apartment complex. The security guard in the apartment complex observed the defendant. Observed in plain view in the defendant's vehicle 3 catalytic converters that were freshly and jaggedly cut. The defendants were not mechanics. There's 2 defendants in this case. Defendant 1 was under a vehicle cutting the converter. When he saw security, he attempted to escape by jumping into a vehicle where defendant 2 was in the driver's seat. Security stopped them from leaving.
So where was Mr. Johnson?
I'm just trying to figure out if he was the number 1 or number 2 defendant, Judge. 1 second.
Right, where was he? Was he in the car? How do we know if it's him? I don't want to try the case, right? But I don't want to.
Sorry, Judge, in the DIMS, they just identified the defendant 1 and 2. Let me just pull up the offense report really quickly. Okay, so Mr. Johnson was under the car. He was the defendant that was under the car, and then there was another defendant in a waiting
So
vehicle.
was he in the act of taking another one?
Yes, he was in the act of trying to steal a catalytic converter when the security guard caught him.
I am now going to revoke your bond on your first case. I asked you not to get in trouble. You've now picked up a felony case. Is there anything that you would like to add?
Your Honor, I would ask that the court set a bond and obviously.
I mean, that's,
I understand. Yeah.
that's, each one of those is like $5,000-6,000 and someone has to. Life's hard enough as it is, man. You know, really. It goes with you. Hi, Ms. Sigler. Good morning.
Hello, good morning.
So it's making a firearm accessible to a child. Did someone pass away as a result?
So this one was the defendant, the father of the children. There were 3 children playing. And then the gun or the weapon was found on the bed, and one of the children was trying to get rid of the gun and then ended up shooting and killing his 10-year-old brother, shooting in the side of his head. And I spoke with Caroline on this, but I was more comfortable deferring to you without an agreed rec on what you thought was appropriate here.
I don't know.
I looked at the
You know-
mitigation packet, but
What'd you think?
for some reason, the case is 2 years old and it was only a 7-page packet. I felt that his statement wasn't really, taking as much responsibility overtly for this. And then it was images of their family. I understand all of that, but with 2 years going on, I don't know why this wasn't resolved with the other chiefs or what's going on, but I just wanted to see a little more with it.
Mr. Gutierrez, come up. Come up. Oh, he doesn't speak English. Got it.
Morning, Judge.
Hi, Luis, how are you?
You wanna,
So are you okay with going without an agreed rec? Ms. Siegler? Are
Sorry.
you okay with going without an agreed rec? Where was the weapon initially? Do you know?
It was found on the bed.
fue encontrada en la cama.
Just a gun is laying, a gun is just, well, I mean, do we know where it was initially before it was used? I guess that's my question.
There were several guns in the house. If you, one moment, let me pull up the OR, but this one that was involved in the accident was found on the bed. One second.
Un momento.
The mother, the complainant, or sorry, next of kin advised that she was told that one of her children was trying to make the bed and in the process moved the firearm and it was discharged. And the child did not know that the gun was loaded.
The worst, that's a worst nightmare.
I know.
Just, it's awful. I don't know. I don't. I think that there has to be some punishment, right?
Your Honor, we're happy to speak to him and have him redo his mitigation packet.
But the thing is that he's had the chance to do it. You know what you're supposed to do. And if you can't own up to it at that time, then, I mean, that's truly what you mean at that time. Right? So I'd like to see it, if you don't mind, his letter, to see
Of course.
how he feels. Is he truly remorseful? You know, because, you know, on one end, I would think that the fact that your own child is dead because of you, is that punishment enough? Right?
That's where I was at too, Your Honor, which I was conflicting on.
If you can't even take responsibility for it, I mean,
And
You
the
know,
next of kin, the mother, the prior chief did speak with her in person. We followed up with her over the phone. And she has expressed they've all been to therapy, obviously, and she said to leave it up to us.
are they still together? Is the family still together?
Yes.
So let's do this. Let's get the plea done. I'd like to get it done today. It's 200 days old. Do it. There's going to be some. Okay? Not as much, but there's going to be some. And then, but then I'd like to see his letter first, though, if you don't mind. Okay? And then
This is in Spanish, so.
it's okay. I can read Spanish. And then, do you want to go ahead and write it up and do it today? Or do you want, tell me how you want to do this.
I would, whatever the recommendation is, I would like some time to talk to him about it.
Okay.
And if he would like to take it today, then we can take it today, but if not, then I would ask for something short.
No, if he doesn't take it, we're going to set it. It's 200 days old. It's time. So I guess let me take a look at the letter. Let me read it and then I'll get back to you. And then give me 15 minutes. Let me just talk to them and then, okay?
Absolutely.
Okay.
Thank you so much.
Sure.
I'll print it right now.
Thanks. Hi, Will.
Morning, Judge.
Shh. Mr. Trevor Maines, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. Oh, guys, crap. I'm sorry. Sorry, John D. And thanks, Mark. This is Mr. Trevor Maines. It's the last name, Trevor Maines. I guess under Trevor.
Sorry about that, Judge.
It's okay.
So officer, are you ready for me?
Yeah, okay. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Officers were dispatched to a bar in Harris County, Texas, in response to a suspicious person. The complaining witness, a security guard, told the officer that the defendant had left the bar and gotten into his car, but then returned a short time later carrying a gun. While there were other parties arguing in the outdoor area of the bar. The defendant took the gun and threw it under the fence. The complaining witness retrieved the gun, took the bullets out, and returned the gun to the defendant and told him to leave. Complaining witness then observed defendant go to the back of the bar and hop the fence to get back inside.
So they had told him to exit the bar, you said?
Yes, Judge.
Okay. Mr. Trevor, I'm going to find that there's probable cause to go forward with your case. How old are you, sir?
7.
What do you do with yourself these days? What do you do with yourself these days?
Self-unemployed, I don't have a job.
How come?
Just moved here. Moved out here.
From where? Okay. What are you planning on doing with yourself?
Job.
Okay. How long has it been since you've had a job?
Like 2-3 years ago.
2-3 years since you've had a job? How do you support it? How do you live? How do you eat? How do you get money? Okay.
Trouble. See my record. I don't be in trouble.
Does he have any prior criminal history?
Just carrying a handgun in a motor vehicle that was dismissed.
I'm ordering you as a condition of your bond not to go back to this place. Do you understand? Not to be in possession of any weapons. Do you understand? So how are you going to get a lawyer, sir?
Get paid for them.
So you're just going to do nothing and
You sign me a
so I don't want to talk to you, the case. I don't want to talk about the case, but let me ask you this. You haven't had a job for 2 to 3 years. Why should the people of Harris County have to foot a bill for you when you get to do nothing for 3 years? How is that fair that we all have to pay for your lawyer when you don't do anything? You get to play Xbox all day, just hang out at home and do nothing, and we have to foot the bill for that? How's that fair?
I don't have it. What you want me to do?
So here's what we're gonna do. I'll have you fill out an application. I'm now making a condition of your bond. You got to get a job. And I'm gonna bring you back in 2 weeks. I want to see what you've done to get a job. You're 27 years old, dude. This life is really, really tough without money. And the older you get, life doesn't get easier. It gets harder. You get bigger, you get fatter, you get uglier, you lose hair, right? And if you don't have a job, if you don't have a trade, if you don't have a way to make money, what do you think's going to happen? Do you think people are going to keep giving you handouts the rest of your life? That's how we have all these people who walk the street looking all Quasimodo-like, have no way of getting money, no traits, no skill. That's not the way to go through life, man. Now is when you work your ass so that when you become 60, when you become 70, you have a cushion, you have somewhere to land. So you have a house, you have a nest egg savings. Because if not, I'm going to tell you now, you're going to have a really rotten and miserable life. This life is a journey, and it's really a good journey where you buy nice things, have nice clothes, take nice vacations, pretty wife, kids, or it can be a rotten toilet of an existence where you're in and out of jail. You ain't got no money. You're begging every single person for this and for that. And that's not the way to go through life. Did you even graduate from high school? I want you to get a job. I will give you a lawyer today. But you're not to use alcohol. You're not to use illegal drugs. And I'm going to test you like crazy. I want you to know that now. And I'm going to hold you to a standard as well. Do you understand? And if you don't, life's not going to go well between you and I. I'm just telling you that now. You will be held to a standard. I'm going to bring you back in 2 weeks. And I want to see what you have done to get a job. If you come back here and you ain't got nothing in your hand, it's not going to go well. Do you understand? You might give an application. All right. Good morning, Mr. Daly. What would you like?
So Judge, two things. I've talked to Madam Prosecutor on this case, Judge, and I'm approaching on two things. One, bond reinstatement and PC on this case, Judge. She and I have already discussed it on this case, and we just both want you to hear the PC if we can, Judge.
Okay.
And then on the bond reinstatement as well, Judge.
So officers initiated a traffic stop in Harris County, Texas for a vehicle having a fictitious plate bearing the word traveler on it. During the stop, the defendant refused to provide.
Traveler? Okay.
During the stop, the defendant refused to provide ID or insurance information, stating, "I do not consent to this." Officer attempted to remove the defendant from the vehicle, and defendant actively resisted by pulling his arm away from deputies until he was detained.
Okay. Tell me what.
So we looked at, I'm sorry, Madam Prosecutor, the interference with duties of public servant, Your Honor. Even if my client is failing to give them that, then it is an arrestable offense. But in this situation, it is, Judge. However, in this particular situation, he didn't interfere with anything in terms of his own arrest. I can, if it was a resisting or something to that effect, I can.
They're just trying to get him out of the car.
I don't
And
disagree.
It's classic sovereign case where got the license plate, think that traveling by right is what I think how they term it.
In this situation, Judge, and the reason I'm employing upon the court is, even from what Madam Prosecutor has seen on the video, they're pulling and tugging at his arm, which put my client in some fear. It was more than one officer. It was pretty.
But he still has a duty. If they're asking you to come out, they can lawfully do that. And there are videos, and go on YouTube, right? There are hundreds of videos where officers will literally destroy your car to get you out. When you get into a pissing match with a person who has the power of arrest, who's going to win, Mr. Daly?
We don't disagree, Your Honor.
Right. You know what I mean? That's real life.
We don't disagree, Your Honor. I think under the circumstances of what actually happened, it was not Mr. Daly's position to resist or to interfere. That was not. He was concerned for his safety at that point. And actually, I don't know, did you hear that on the video? Right. And so in reviewing the video, it was pretty quick, pretty brash. They didn't give him an opportunity to respond per the prosecutor. In this situation, it wasn't as if he was intentionally
Remember,
not.
this is just a mere probable cause.
Yes,
So,
Your Honor, I agree.
they ask you to come out of the car one time. Yeah, it's really, so, I think that there's enough probable cause to go forward now. The problem is, Mr. Daly, is that we revoke your bond is set at 2501, and you've continually failed to appear. So, the case and the way that you've treated us, it shows me that you just refuse to accept authority. How are we supposed to deal with that? How do we deal with that, Timberland?
Your Honor, the only reason I bring to your attention is I asked the court to take into consideration, we have a Black male works every day who, and I hate to put that on the court, but I do in this particular climate, that has never been in contact with any particular law enforcement court system. And from what I can see and what I hear out here from a lot of my Black male, and I'm sure it's common knowledge, is that because they are unfamiliar with the court system, they don't know, number one. Number two, when they do come in contact with police, and my mother is assistant chief of police. So I can understand, even when I was younger, I was taught that there are certain things that you have to do with when a police officer even stop you on a speeding ticket. What we don't know is whenever these officers come up, when you're somebody who don't have the privilege of having a police officer as a parent, or who isn't familiar and is being raised in this particular climate and seeing what they see on TV and seeing what they hear and everything that has occurred, you don't know what the proper steps are. I was trained from when I was grown up, what you do. I'm not saying that what he did was right or wrong. I'm not saying that how he reacted to this particular court, it is wrong. However, I'm employing upon the court to ask the court to take into a little bit of consideration. Number one, from his perspective, all defendants can't just say this, but I do see that, from what I've known from this particular case and now in talking to him, I do believe that there is a sense of, sometimes they just don't know. Sometimes they just don't. So I'm asking to reinstate his PR bond. I am now on the case. What you know about me, I'm a tight attorney. I run a tight ship. So, and by which of way I believe I can reach him and getting him to court and resolving this matter, which is what I talked to the prosecutor about when you were on break. It's like, let's just resolve this. Let's take care of this.
I'll buy it.
Yes, sir.
Okay.
Thank you, Judge.
I'm not going to do this again, though. I promise you. I don't care whoever you have. If you flake on us again, that's 3 times. It's out. I'm not going to do it again. Do you understand, Mr. Daly? I mean, when you come to court, good things happen. When you don't show up and you continually do it, you can't expect good things to happen. Now, do you have a Texas driver's license?
Not right now.
You're not allowed to drive.
Right.
You have a bond condition and you've signed an affidavit with me today promising you're not going to drive. I don't care how you term it. Driving, traveling, however you're going to word it, whatever you do not get into the driver's seat of an automobile, a motorcycle, anything with a combustible engine where you can get on the road unless you have approval from us. Do you understand? I don't care that you have to work. I don't care if you have to go to church. I don't care if you're going to a funeral. I don't care if you're going to wherever it may be. Do not drive. Do you understand? Heed this warning. You're not going to get another one. Okay, Timberlake, I'll reinstate the bond.
Thank you, Your Honor. And I'll talk to her. We were going to try to talk to Chief, but it's pretty busy today.
I think the case is only 3 months old,
Yes,
so you've got time. You can do whatever you want.
Yes, sir. Thank you, Judge.
Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court now, but you must stay in touch with her and she'll tell you when you got to come back to court. If she comes back and tells me she can't get a hold of you because you're playing games or you've gone AWOL or whatnot, or you get arrested for something else, all bets off. We good? I'm not asking for much, man. Really. And for future reference, when you get into a pissing match with someone with the power of arrest, you are nearly always going to lose. It's just the way it works. And as a young Black man in today's society, you got to be extra special careful because things can go really wrong really quick. And there's evidence of that over and over and over. Okay? All right. Good luck, guys.
Thank you, Your Honor.
Yes, ma'am.
Thank you, Judge. Thank you. Thank you. You want to show this to Chief?
Yeah, I just sent her.
Thank you.
Yeah, of course.
You're Stephen Benito. Mr. Benito, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On 4/29/2024 in Harris County, Texas, officers observed a vehicle run a red light and they attempted a traffic stop. The vehicle evaded for 0.59 miles, speeding 63 miles per hour in a 30-mile-per-hour zone before crashing into a tree. The driver detained the defendant got detained and was sent to Woodland Memorial Hermann Hospital for his injuries. Officers recovered a bag from the vehicle containing a firearm. So he ran a red light, they attempted a traffic stop, he evaded for 0.59 miles, and then they found a firearm on him.
Where was it? Don't say anything.
He was traveling southbound in the 29800 block.
No. I mean, like, where was the gun? I guess, yeah. No, it's a company in the felony. Mr. Benito, I'm going to find that the probable cause I'm going to find probable cause to go forward with the case. How old are you, sir?
He was inside the center console.
You're 17. What do you do for a living, sir?
Now work. Company.
Are you in high school?
Online school. Online school.
What does that mean?
Yeah, I'm enrolled in online school.
Okay, I'm sending you for a drug test. And I don't want you to smoke weed. I don't want you to use alcohol. I don't want you to have any weapons. Do you understand? Do you have a Texas driver license? You're not allowed to drive. You will be signing a promise with me today, Mr. Benito. I want you to understand that I take it extremely serious. You are only 17 and you're starting your life out now. You have an open third-degree felony. You're looking at up to 10 years in prison. This is not a good way to start life, man. Really. You have your whole life ahead of you, and I'm going to tell you, you end up in prison, it's a veritable nightmare. We're going to do everything in our power to make sure that you go on the up and up. I want you to stay in school. That's also a condition of your bond. Do you understand? I don't want you out in the middle of the night. I'm giving you a curfew as well. I'll give you a lawyer today, but we're going to work hard and fast to make sure that you go on the up and up. You understand? No more weapons and no driving. Who are you here with today? How'd you get here? Okay, don't drive. I'm not asking much.
Judge, it was in the center console. I just need to review the report.
Okay. This is an affidavit. This is a promise that you're going to make to me. And if I find that you drive, and I'm telling you, I don't care what your reason is, I can have a contempt hearing. You can be facing up to 6 months in jail and a $500 fine every time you drive. The problem with driving without insurance, Mr. Benito, is that if you get into an accident, and let's say you kill someone in that accident, who do you think they're going to come after? Right. No, not after you. They're going to come after the deep pockets, which are probably mom and pop. You don't want that to happen. You understand? Come on. So let's send him for a drug test. We'll have him come back, appoint a lawyer now, and then we'll, get with the lawyer to see how we go forward with. Happy with you, Mr. Jones. You've now picked up a third case. You now stand charged with failure to identify oneself. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 5th, 2024, officer initiated a traffic stop on defendant's vehicle for failure to display a front license plate while he was driving in the 5900 block of Mercer Street in Harris County, Texas. Officer made contact with the occupants and detected an odor of marijuana emitting from the driver's side window. All three occupants were detained for a PC search. The defendant provided the name of Kendrick Johnson with a date of birth of 8/30/2006, which returned with nothing. Officer used a mobile AFIS device and found defendant's real name to be Jamarcus Jones with the date of birth of 8/30/06.
I ordered you as a condition of your bond, and you promised me when you got here last time that you would not drive. Stop. Did you say that he was a driver here? Stop. Don't say anything. I don't want you, don't. You have the right to remain silent. Exercise that right. I was under the impression, Rosette, that he's driving here, is he not?
There were three occupants in the car, Judge. I'm trying to see if they clarified. He was a passenger. He was the front passenger, Judge.
Okay, so tell me, let's do a deeper dive.
Sorry?
Let's do a deeper dive. So they pull him over. He's the passenger.
There was an odor of marijuana detected.
So what happened next?
So they detained all three occupants for
Okay.
a probable cause search.
All
The
right.
driver was identified by his driver's license, and the front seat passenger, which is the defendant, provided the name of Kendrick Johnson. And a mobile AFIS revealed that that wasn't his true name. And so he was charged with failure to ID.
Do we have any co-defendants in this case?
Yes, John Burns.
Okay. So what's the cause number on that?
On that one?
Yeah.
It's 25-417-01. That's in court 15.
Okay, is there a third co-defendant as well? Okay. Mr. Jones, I'm glad that you're not driving. Regardless, you've picked up a new case. I don't know what we're going to do, but normally when you pick up a new case while you're on bond, we revoke the bond on the old case. So, I mean, it goes with you. I'm going to appoint your lawyer today. We'll figure out how we go forward. But for now, I'm going to take you in. I'm going to appoint your lawyer. We'll see how we go forward. But you're supposed to behave yourself while you're on bond. You've now picked up a third case. You first have a felony theft. You got a second case, and now you've picked up a third case. It goes with you. Can you please, one number one? Hi.
Good to see you, Judge.
You too.
I'm here on Mr. Benito, Benito. Young man got appointed in this case this morning. And he's present here in the courtroom.
Okay.
A couple things, just a little bit by way of background. The state and I have talked about what I think may be some issues in the case. I think as far as a bond condition, he was sent over for testing. I think this is his first appearance here. My understanding is the results of the testing came back positive for marijuana. I've talked to him about the importance of not having that issue moving forward. So we're aware of it and we'll address that. I talked to the state about what I think is a legal issue that exists in the case. I don't know that it exists from a probable cause standpoint at this moment, because I don't know that the officers had enough in the way of developed facts. The interesting issue is our chapter 4602 statute about unlawful carrying of a weapon does not apply to a person who is traveling under the code. But I think that requires some factual development that was not within the officer's purview at that time. So I won't belabor the court with all those details.
Okay.
He's got the felony charge that's still pending. But we're aware and will not have.
And I think it's did you say it's 0.5 of a mile for the evading?
It's about a half mile. Yeah.
Okay, I thought it was something like 0.5. You said something like that. All right, Mr. Benito, we're not asking much. Don't use marijuana. I'm telling you now, you will be tested in 45 days. If you continue to use, what happens?
You understand, Judge?
You understand? Okay, I'm not asking much. Stay in school. Try to be the best person you can. Don't pick up any new cases. Don't drive because you don't have a license, and don't use marijuana. That's it. Were there co-defendants in this case?
No, that I see.
Okay.
Judge, I just put it together. 0.5 is a half a mile. But my math is slow.
They
so-
say 5.
0.59 miles, half mile, a little over half mile.
Aye. Okay. Be good. It's not hard. Okay.
Yes, Judge.
All right, kid.
Thank you.
Have fun. Come up, Mr. Jones.
Mr. Nayland is in Cancun until Monday of next week, Judge, so he's not available this morning.
I
So I'm kind
understand.
of filling in. I have had a chance to look at this violation report regarding Miss Blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
It says 19, Your Honor. That's 7, within that 7 are included. But Judge, I would ask if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So that he can
I'm
do-
sorry, Ben, I can't. I have to know, you have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, you're on cold weather. I apologize. So can I please speak on the breathalyzer?
No. You know what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please,
No.
And
It's you.
but to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate, for alcohol.
I go to sleep early, man.
Test. And he is blowing outside the window, so we don't know what he's doing.
My God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pretrial over there, and they said that I had the 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor, I will do anything. I'll even go on that drug, ankle monitor. I'll do anything, Your Honor. I'm really trying here. I swear to God, I will do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor, it's just, I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I do wake up. And they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one pass after the other. He goes with you. No.
Oh my God.
Your Honor, may we discuss setting a new bond further?
Of course.
Oh my gosh, Your Honor. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I will now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view it. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera, then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 75-2, Judge Fleischer.
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't, but fine. Because, fine. All right, Mr. Trevor, do you mind getting a cell phone, please? Do you have a pen or do you need one? I need your cell phone so I can give it to the lawyer. If you look on the TV, that is Mr. Greg, who's been appointed to represent you. Your cell phone, please. It is your responsibility to stay in touch with him, Mr. Trevor. Thank you so much. It is your responsibility to stay in touch with him. You know what the expectation is here. Do you understand? Yes or no?
Yeah.
Okay. I'm not asking for much. I want you to be the best person that you can be. Believe it or not, we want to help you. We want to make sure that you amount to something in this life, not just do something. Do better. Be better. If he tells me he can't get a hold of you, if you pick up a new case, you violate conditions, I'm going to revoke the bond. It's very possible you will not get any more PR bonds. Do you understand? You got out of jail because you were given a free bond. But for those who are dangerous and for those who continue to violate laws, they usually do not continue to get PR bonds. I want you to know that. And I want you to know that we're going to protect our city at all costs. So what we'll do now is, have we had him sign a reset yet, Victoria? Mr. Trevor? Okay, so we'll just have you step outside. You'll be able to talk to your lawyer, and after that, you'll be free to go. All right. Okay, man. Greg, did you want to say anything?
No, just call me. We'll speak about your case. I'll look at everything. Was PC found already, Judge?
Yes.
Okay.
There it is.
I got his number. I'll shoot him a text right now. And then,
chatted you his phone number there. His phone number will be on your reset so that you will also have a copy of it as well. If you ever have any issues, if you lose your paperwork, if you're unable to get a hold of him, if you ever have a problem, all you have to do is come back here and we can help you out with whatever you need. If you need resources, whatever it may be, come back, ask, and we can help you out. But communication is key. If you don't communicate, we just can't help you. All right? Okay, man.
Judge, how much time did you want on that one?
Good morning, Mr. Colegio. Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 30 days in jail, credit for the 12 days that you've done. You need to understand that this is going to go on your record. It's going to be there for the rest of your life. What happens next time?
It won't be a next time, sir.
If I had one strand of hair every time someone told me that right there, I would look like you with hair. Really. If I had one strand. You need to understand that both of these are going to go on your record. They'll be there forever. Even if you have a sip of alcohol, if you get pulled over, an officer's going to see DWI, 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 they're going to probably take you right in. From now on, you're facing a 3rd-degree felony, 2 to 10 in the penitentiary. Do you understand?
Yes, sir.
So I wouldn't get in the car even if you've had a sip of alcohol, because if you thought this was bad, wait till you get to felony court. You're giving up the right to a trial, right to compel witnesses. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it goes on your record. You can never take it off. You understand?
Yes, sir.
You still want to do this?
Yes, sir.
How do you plead to the offense, sir? Guilty or not guilty?
Guilty.
It's alleged that you had an open container. Is that true or untrue? Did you have an open container of alcohol in the car?
Yeah.
I did discuss that.
I'm going to abandon the second enhancement, but that's an enhancement that makes it a minimum of 5 days in jail to the case, which you've already satisfied it, obviously.
Okay.
But it's still an enhancement that they have on there. They actually have 2 enhancements. Your second enhancement is one that you had. Actually, there's 3 enhancements, actually. So it's also alleged here that you had a prior DWI in County Court 5 in Montgomery County. Is that true or untrue? It's also alleged here that you had a .15 or above. Is that true?
I would, due to the actual results, I would ask them to abandon that one.
Okay, I'll abandon that one. I got to look to see because that one might make it 90 days though.
The NCAC code has to change. Because it's a DWI second with a 0.15.
It's a second.
With a 15.
Okay.
So we need to, so.
Because it is a 0.14 and a 0.15, so I would.
Do you know what the new NCIC code is?
It will be just a DWI second, right?
Yeah. I don't have, do you guys have the NCIC code for just a DWI second?
Yeah, I think it should be the 14.
I don't know. I want you to understand that there's another big thing about this, Mr. Colegio, that DWIs are big business in Harris County. You know, this right here, there is a $6,000 surcharge that goes on you because this is a second offense, plus court costs of around $500. So, because you're in custody now, I'm gonna end up waiving it because you're in custody now, but the more DWIs you pick up, the worse life gets. And it's so easy. All you have to do is hit one button on your phone, $40, and Uber will take you wherever you want to go, man. Don't get into a car again if you've had alcohol, because it's not going to end up well. Did you find a chance?
Yeah, yes, Judge. I think the paperwork may have to be refiled. I'm not entirely sure. But she's gonna work on it.
Okay with abandoning the 15 enhancement?
Last name again?
Colegio, COLL.
AGL.
So that would do. And what's the logic behind that?
Well, one of my fear was that it would make the minimum higher, but
Don't worry about it. Don't worry about it. Pretty high, that's why I was, that's what my understanding was, I didn't know that. Mhm. That's scary. That's why I kept it and it's was 3. 30 is why. The training.
Okay, so I just say.
you would, yeah.
Okay.
Your breath.
Okay, yes, sir. Gotcha.
So we can continue with the plea as written.
Okay, so is it true that you had an open container? Did you have an open container?
Yes.
No, you were there.
Yes, yes, sir. Yes, sir. Yes, sir. Yes, sir. Yes, sir.
Okay. Is it true that you had that prior to DWI?
Yes, sir.
And it's also true that you had a 0.15 or above?
Yes, sir.
Okay. You know how to act. You know what to do.
Yes, sir.
Just be good in the future. We're not asking much, we want our streets safe. How do you plead to the offense? Guilty or not guilty?
Guilty, sir.
Find you guilty. I will follow the agreements. For cost. So I'm going to waive the DPS fees. I still need that order, please.
Yes, we'll do it.
And then I am going to suspend your license for a year. Do not drive. It's a DWI. It's a second DWI. You're
Okay, yes,
pleading
fine.
guilty.
Thank you, sir. Thank you.
Look,
Fine, thank you.
you're going to get out of jail.
Okay, can I get an ID, like a regular ID to start working?
Well, of course you can.
Okay, I'm just asking. That was the reason I turned myself in.
Glad that you did.
Thank you.
You're getting out of here probably today. When you get out, don't start driving.
Yes, sir.
Call DPS. They can tell you how to get your license back. And then when you do things the right way, good things happen. If you go out there and you start driving, even though you got to work,
Yes, sir.
Murphy's Law, what can't happen will happen. You're probably going to end up getting pulled over and you're going to be right back over here.
Sure.
So do things the right way. Good things happen. All right. Good luck. Thank you. Thank you.
Yeah, they heard from me last week. I was in Cancun. I guess there's a DVR for positive alcohol.
He's out now. Don't want any more issues. Just. Don't want any more issues. I'm not asking much. Just do what you need to do. Really, you know?
Judge, pretrial, I talked to pretrial, they said they listed it about the THC rating. I don't know what you wanted.
God, it's only 70 days old too.
So Judge,
All this trauma and it's only been 70 days.
is that it? The lab is back. There's no alcohol, which we expected that already. We're still waiting for drug analysis, but I think as soon as that's back and the state's ready, we just either just try it or, just try it. Let's get done.
Is that where this is headed?
Well, I looked at I've evaled it, and I don't think it's the DWI. I don't think it's intoxicated when I looked at the eval, but but the state can't do a full eval until they have their labs for the blood. And
Tell me what you think.
I expect that.
I mean, I'm going to tell you now, this has so much drama, Ms. Saba, that I'm like ready to pony it up with Dustin as well. You know, I don't want to sit and wait another 6 months. And
Judge, we don't,
oh, that's wonderful. Hi, you look great. You know,
what were you?
It's gonna be an alleged drug case.
Oh, yeah. We
Is there a
just don't
DRE
have the
done?
toxicology report
DRE?
yet, Judge.
I can hear you, I'm sorry.
DRE, shh. Was there a DRE?
DRE? Yeah.
We just don't have the toxicology report yet, Judge, and the case is only 2 months old.
I know. No, well, yeah, a little bit over, but yeah.
A little bit over.
How long do you think it'll take?
I think it should take one more month, because sometimes I've seen them take up to 4, but maybe we can give it like one more setting before we.
Yeah. Okay, we'll sit you off 30 days.
Still have them come in to do drug testing.
Yeah, just don't use, you know? All right, so we'll continue supervision now, Felicia.
Judge, just to clarify, so you are permitting the usage of THC?
No, I don't,
So that's like the dilemma here.
I know.
So I don't, because we're just gonna continue about, we have.
Yeah, I mean, how do we deal with this? I don't,
Let's get the labs back and
Yes,
eval it and try it.
I'm not down with you continue to use marijuana. I'm not down with it, Mr. Jones. I don't want you to use. There has to be an alternate method to dealing with issues.
See a doctor and all kinds of stuff still though.
Yes,
Sure.
yes, that's what you're supposed to do. You're not supposed to self-medicate.
He's not self-medicating. He's got a prescription for marijuana. And I know we've gone down this road already. So he's not self-medicating. He's under a doctor's orders.
He has a second DWI that's open. I don't want you using, Mr. Jones. Just the plain and simple of it. I mean, don't. Do you understand? Don't use and get ready, please. It's way too much drama. I'm ready to put this baby to bed one way or the other.
We'll reach out to the lab and do an
Please.
eval.
All right, I'm going to do 30 days. I'm going to continue it now. Don't use. You've got 40 days. Do you understand? Yes or no?
Sir.
Okay, get ready. All right, Dustin.
Stop right
Good
there,
morning,
members. Because what just happened in this courtroom may be the hardest question any judge has to answer. A father stood before the judge today on a charge of making a firearm accessible to a child. His children were playing. One of them found a gun on the bed, tried to move it, and accidentally shot and killed his 10-year-old brother. The case is 200 days old. The family is still together. The mother told prosecutors, "Leave it up to us. The surviving children are in therapy." And the judge sat at that bench and said out loud what almost no one in that room wanted to say. "Is the fact that your own child is dead because of this? Is that punishment enough?" He paused. He asked to read the letter. He wanted to know if the father was truly remorseful, or whether the statement was crafted to minimize. He said, if you can't own up to it, that's truly what you mean at that time. So here's the question, and there is no clean answer. When a father loses a child because of his own negligence, not malice, not violence, but an unsecured firearm in a home full of children, what is the purpose of criminal punishment? Is it accountability? Is it deterrence? Or is it the law saying, regardless of what you have already lost, society still has something to say about this? And when a judge sits there and asks whether grief is enough, who has the right to answer that question? He said, there has to be some punishment. Not because he doubted the grief, but because the law does not get to look at a 10-year-old who's no longer alive and say nothing. That is not what it was written to do.
Good morning, Mr. Hinojosa. Good morning. How are you doing? Sir, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have two cases, actually. You've got the DWI. You also have the unlawful carrying of a weapon. I'm assuming that one is...
No, that right, yes.
They're going to dismiss that second case against you. You need to understand that this DWI is going to go on your record. It's going to be there for the rest of your life. What you need to understand is that whenever you get pulled over, an officer is going to see this. If they smell alcohol or they smell dope and they come up and they look that you have a prior DWI, you think things will go well? Probably not. So what I'm telling you is that you now have this DWI that's going on your record. If I were you, I would never get into a car, even if you had a sip of alcohol, because you're taking a humongous risk. Do you understand? After today, you will also have a minimum of 30 days in jail for any other DWIs that you pick up. You can use this to enhance your punishment to a minimum of 30 days in jail. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you accept this agreement. You can never change this or undo this. It will go on your record. It's going to be there forever. Do you understand? You still want to do this? How do you plead to the offense of driving while intoxicated? What have you worked out, Mr. Morgan?
There's 1 year probation, 30 hours community service, no drugs or alcohol, random urine analysis.
So it's
180 days.
So the agreement is this: for you to successfully complete this probation, it's 180 days in jail. We will probate that for 1 year. As part of the probation, you will do one victim impact panel. What about a DWI education class?
Judge, he has a, judge, that's fine, we can add that in there.
It's not in here now. And I'm going to tell you, Mr. Morgan, that if he doesn't do the education class, they'll probably end up suspending his license. I don't know for sure, but from what I understand, the rule is that if you do the DWI education, the DWI education, it doesn't suspend your license. But did you mean to add?
Added in, Judge.
Oh, it was an oversight.
Accident on my
Okay.
part.
Got it. So you must do a DWI education class, a victim impact panel. No breath test refusal. If you were pulled over in a car and an officer asks you to submit to a breath sample, you must take that sample. Random urinalysis. No drugs, alcohol.
He has 100 hours service upstairs. Two guys
Do you have any children?
You're doing the 30 hours here.
Mr. Morgan, I was gonna.
About the community service. Yeah.
He's on a deferred in felony court as well, Judge, where he has to do community service anyway.
Okay, I was gonna pick that off anyways. I mean, what
We appreciate that, Judge.
what I normally do, what I think would be more prudent is if they have children to do like a parenting class in lieu of, but he doesn't have children, so I guess we'll just.
Judge, he's fully employed, so. He's on his way to become a productive member of society, I imagine. Starting a family at one point, once he's a little more financially stable, will be where he needs to be. Still pretty young though.
You're on felony probation now. You have to have a freaking halo over your head. Because if you don't, you could go to prison for a very long time. Have you been to prison before? If you have any doubts, go online and look at how miserable prison is. It's not a fun place. And I will tell you, there are some parts of prison that the lights don't even go off where people sleep. You can imagine how you have no REM sleep, how much that will play on your psyche and your hormones. It's incredible how bad Texas prisons are. There's no air conditioning. It's freaking awful. If you don't believe me, go look it up. You're on this deferred now, so you got to behave. Do you understand? All right. If you violate this agreement, I'm going to issue a warrant for your arrest. I'm going to put you back in jail. I'm going to bring you right back out, and we're going to talk about whether you violated this agreement. If you violate this agreement, you're looking at up to 180 days in jail. Do you understand? Okay. There's what do you do for a living? How much money do you make a month?
Judge, it's contractual, so it's whenever he has business.
There's a surcharge and fines and fees,
Yes.
Mr. Morgan.
And yeah, if we could waive that, as he has a forfeiture pending that is about to make him completely indigent.
Forfeiture?
Yes.
Oh, they took the car?
They took the car and he has been without transportation, and it's been a struggle to make ends meet. So
What kind of car did you have that they seized?
Okay.
Oh my God. Oh, Lord.
Yeah, no, he was.
Is that like a $90,000 car? How much was that?
Yeah.
Yep.
You right on the dot right there.
Yep. Yep.
Wow.
Good, and then.
You know, I will tell you, I routinely warn people here about when they end up racing, they do crazy stuff, donuts and this and that. When they pick up a second one, a lot of the times the cars get seized. We see it every now and then when it happens, and here's tried and true. This is a second case, and man, that's someone's going to get a benefit nicely from that.
Yep.
I hope that you get it, from now on. You don't have to say anything, but I'm just really, actions have consequences, and that's a hell of man, I wish I had that kind of car. Here I am with a jalopy. Drive a nicer car than I do.
But with that being said, Judge, if you would be so kind as to waive the surcharges, that would be ideal.
We want you to learn from this, Mr. Hinojosa. This is your first DWI. I will acquiesce to Mr. Morgan, but I'm going to tell you, if you're not smart enough to consider how to get home on a night of drinking and you act like a child, we will treat you like a child. But the way we do it, the way that we spank you is with a ton of jail time, Really, you act like a child, you'll get treated like a child. And I'm going to tell you, I'm waiving nearly $3,500 in fines and fees and surcharges from you now. But I'm going to tell you, a second DWI, it's $6,000 surcharge, not to mention court costs. So you can probably roll out of here with about $7,000 in fines and fees. You pick up a second one. Do you understand? Get a clue. It's not hard. All right, done. I need you to do a waiver for me.
Yeah,
and then
sure.
I'll grant it for you. And then, all right, good luck.
Thank you, Judge.
Oh,
We agreed to no device.
is that the agreement?
Yes, Judge.
Okay, that's it. I'm going to tell you, we're going to test you. I'm going to test you like crazy. So I know that you're not using. If I find that you use, one of the sanctions that we can do is either a guardian interlock or a scram device. Those devices are hundreds of dollars a month. Don't drink. Don't use illegal drugs. Do you understand? Okay, man.
Thank you, Judge.
Great to see you like always.
Great to see you, Judge.
Okay. Good luck, Mr. Hinojosa. Good morning, Mr. Venable.
Yes, sir.
Mr. Venable, you're charged with 2 counts of assault. One is of a family member. On both of those, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay, Ms.
On January 21st of 2024 in Harris County, Texas, officers were dispatched to an AFM call. Officer met with the complainant. The complainant and the defendant have been dating for 5 months. The complainant and the defendant were arguing. The defendant pushed the complainant to the ground, causing her to scrape her right arm. While the complainant was still on the floor, the defendant stepped on her neck. Officer noted.
Stepped on her neck.
Yes, Judge. Officer noted redness on the complainant's arm and neck.
You know if it impeded breathing?
No, Judge. I don't, I can't, let me check. It wasn't charged as an impeding breath, so.
Well, I know it wasn't charged, but is it?
The DIMS don't say that she had any trouble breathing, but I'll look at the offense report, Judge.
And here's the other thing. The first assault is from October of 23. The second assault is from January of this year. And now we have a felony evading arrest on December 10th.
Yes, Judge.
Were these 2Bs? Was he out on bond for these? Vic, do you know?
It looks like. No,
So
it
this is
looks-
Venable, who's now picked up a third case. He had 2 misdemeanors, one's from 23, one's from 24. Did we ever do PC or had he ever been on bond
No, Judge. It was just a non-arrival.
for the whole time? All right.
Judge, it doesn't say that she had trouble breathing. It just says that it caused her pain.
Okay, can you do probable cause? So that's the family member, right?
That's the AFM.
Okay,
Judge.
can you do the first case? Because I don't think we've done probable cause on that one now.
This is the AFM from January 21st. Oh, the ABI, the one before.
Yeah, the one before.
On 9/29/2023, officers were dispatched. On arrival, officers spoke with the witness, the complainant's wife, who said that the defendant assaulted the complainant by slapping him in the face because the complainant's dog killed the defendant's girlfriend's cat. Then officers spoke with the complainant, who said he had invited the defendant into his residence to discuss the situation when the defendant said she should knock the shit out of him. And the next thing complainant knew, the defendant had struck him across the left side of his face with his hand, causing pain.
Mr. Venable, I want you to understand one thing, that I'm going to do everything in my power to protect my community at all costs.
Sure.
And if that means I have to make your bond extremely high, taking you into custody, kicking and screaming, I'll do it in a heartbeat. Do you understand?
Sure.
I'm ordering you as a condition, I'm going to find probable cause on both of your cases, and I'm ordering you not to have any contact with either of the people in this case.
Sure.
There's a protective order that has been issued in the family case. I would get to know it. Don't say anything. You will get the opportunity. Now is not that time. I'm telling you what the expectation is while these cases are open, and what the expectation is for you to be able to live in this free world. Because if you don't abide by these expectations, I'm going to take the free world away from you. You are not to consume alcohol or illegal drugs, and I'm going to randomly test you. You're also not to have contact with either of these people, not to be in possession of any weapons, and abide by the conditions of the protective order. If you violate those conditions of the protective order, the state can file a fourth case, a violation of a protective order. If they do, that is the capital murder of misdemeanors. It's one of the worst cases you can pick up, and you violate those conditions, I can have a hearing to hold you at zero bond. Zero bond, and I'll do it in a heartbeat to protect every person. Do you understand?
Yes, sir. Yes, Your Honor.
Do you have a Texas driver license?
I do, but it's
So you do not have a Texas driver license. I am now ordering you also as a condition of your bond not to drive. You will be signing an affidavit with me today promising you that you're not going to drive. I don't care what's going on in your life. I don't care what you got to do. I don't care where you got to go. You violate this, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car.
And Ubering to and from, so.
Don't. There's nothing you can say to justify. I'm not asking you. I'm telling you what the expectation is.
Yes, Your Honor.
We are now going to reset your case to give you time to hire a lawyer. So for now, I'm going to have you come up here, sign this order, promising us you're not going to drive. I will get you to Victoria where we will have you sign a reset for you to go get a lawyer. You will meet with Felicia for your bond conditions, and after that, you'll be free to go.
So,
The one in there that has contact.
got it. Okay. So Rosette, the order in the one that's signed by the magistrate is allowing contact, but I'm going to issue one now so that he cannot have contact. Okay? Just so that you know.
Also, I don't see a motive on the assault bodily injury case.
Well, it's because it's not a family member case. That's why. You can only do one on the family member cases. All right? That way. John D.
Good morning, Judge.
Hey, bud.
Judge, was that CHA? We like Victoria Venable. Oh, thank you.
John D.
Judge.
What's the word?
I'm gonna put him first on young Mr. Cuellar, Diego Cuellar. He's due back today because he wanted some getting his GED. I spoke to him this morning. He had to get an ID in order for him to get his high
I
school.
think he's supposed to come here with his ID today, wasn't he?
Yeah, he showed me a proof that he's applying for it. He hasn't gotten the ID.
Come up.
And he's got proof on his phone that he's been researching the GED program. So he's taken active steps towards the judge. He just doesn't have the ID in order for him to get the transcript.
Mr. Cuellar, you haven't done
In the
absolutely.
GED program.
I have to wait for the school to mail in the transcript so I can get the ID. They said I need my old school record so we have proof of who I am. But I have my GED login on my phone. I can show you.
To go get an ID, all you have to do is go to DPS and get an ID, right?
If they're under the age, they actually have to have a student verification form from a school.
That's what he's waiting for.
I was there
He's got
yesterday.
he's got.
What school is this?
Calhoun High School in Port Lavaca. Calhoun High School in Port Lavaca. I called them yesterday. And they're gonna mail it.
The day before court, you call.
That was when I had my appointment for the DPS.
Okay, so how long are we gonna wait for you to get the ID to be able to start on your GED?
Well, they said they mailed it already, so probably it's like a couple of days, like 3 days.
So let's set it a week. Okay, all right, I'll see you in a week, sir. All right.
Okay, go ahead.
Judge, was that Cuellar?
Yeah.
Yes, that was Cuellar.
Okay, John D, who's
Did you get the
next?
results for his drug test?
Well, you sent.
Second, I'll check.
You sent him to get tested last time, but it hasn't been 30 days, Judge, because you wanted him to come back to show proof. So.
That's all right, John.
So I think by next time, he told me it's clearing out. So that's good. The next one I have, Judge, is, well, we have to approach on Mr. Imamovich, Judge. They're gonna file with an IMA.
Oh, you're dismissing it?
Yes,
Yes, Judge. So we had dismissed the ABI, but I don't think we ever got the MOA dismissed. And so he got picked up on a VPO.
So.
But we don't plan on moving forward with the
Okay,
VPO.
all right, I'll sign it.
Got it, Judge.
Thank you,
And then
Judge.
lastly, I have Mr. Johnson, but they are.
So there's the proof. You see that?
Well, hey.
Even if the case gets dismissed, the DPO still lives on.
There you go, Judge. But it's good news, right things being done.
Yeah, you're doing all right.
Mr. Johnson, they are seeking some chief discussion in order to get that off your docket
The
today.
case
I'm
is
just
not
waiting. No, I got you, but I just wanted to give you an update on it. It might be off your docket today.
She sent me an email from,
If anything, have you done for your GED?
And what I did for it,
What have you done?
I went to a class and then I tried to go yesterday. They canceled it and he also.
You went the day before court.
And I also went before.
Judge, she's been going. She's been going before even the last court date, and we,
Prove it.
I can text you.
In this life, you are only as good as the proof that you don't have. If you don't have proof, you have nothing. Spoken word means absolutely nothing.
Judge, the instructor, I got an email from him that she sent me saying that she's been going to the classes and that class was canceled on the 4th yesterday. But she did, attempt to go to the class. So she's been going. She did already take a test, and this is one where she did fail the first test. So she's been working on it. It's not enough.
I mean, here we are. How many resets have we had? We've had 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 resets since May. You're now in December. You have had 5 to 6 months. Show me the money. Otherwise, it's not going to go well for you today, Ms. Dixon. Show me. 5 to 6 months.
And Judge, this was a case where she was paying for the classes, and then she had to then enroll into the free program, which she's been doing for the last little bit.
Are you playing Candy Crush? What's going on over there?
I'm trying to text you.
Texting who?
The instructor. Like, what I'm supposed to show you? Because I don't have no proof. Like, I don't have nothing.
Tell me what have you done?
I went to the class.
Okay. Which class did you go
The
to?
GED resource.
Okay. And because the way I understand it, there are different modules that you do. You do science, you do language arts, you do math, you do, and whatever else it may be. You go through each section, you complete it, take a test, and then when you're done with everything, you take an overall test, and then you get a diploma.
That's not.
What have you done?
Basically explaining on how everything's going to go, and I was going to finish everything else Wednesday when I was going to go, but the class was canceled.
Who is the provider that you have?
His name is.
Grab me a phone number, because I'd like to call them right now.
I have a number for you, Judge.
I'm going to put this on.
Oh, yeah. Charles Jackson.
Mr. Jackson? Yes, my name is David Fleischer. I'm a judge here in Harris County. And I have someone that's with me in our court, and she's doing a program with you guys to try to get a GED. I'd like to confirm that's Coriel Dixon. So Wednesday and Thursday, and then did you say every other Saturday? Okay. And then, so how does it work as far as getting the diploma? Do you do different classes as far as science, math, and how do you at the end get it? Can I put you, I have her in front of me. Can I put you on speakerphone so that she can hear this as well? Do you mind? Okay, hold on. So, I've got him. Okay, Mr. Jackson?
Order in the court, please.
Okay, tell me, how goes it?
So, yeah, it's kind of twofold. They take an assessment. Based on that assessment, allows me to know where the student is as far as their grade level in math and in reading. Based on that, they go on 2 tracks. And so one track is like a basic education where we're just literally working on kind of some elementary reading and math skills.
Okay.
Or a GED track where they're ready for GED contests. And so, yeah, and I usually just, go from there. I work with my GED students individually. And
how long does the process take? And how long can we expect it?
Well, so that's honestly kind of a loaded question, depends on where they fall. I believe Coriel scored pretty well.
Great.
So yeah, and I worked with people that have gotten the GED in 3 weeks. I worked with people that got the GED in 2 years.
Oh, yeah. I can't do 3 years. That's too much.
Well,
I know, I'm kidding.
No, I understand that.
She's been faithfully attending though? Yay or nay?
Yes.
Okay, great.
And with some consistency, 3 to 4 months, maybe less.
That sounds great.
That's just me ballparking.
I'd like to stick with it because I think at the end of the game, our goal here is that she ends with that diploma. And I think that would be a win for everybody. I'm calling you. I want to make sure that everything's going well, that she's attending, faithfully attending and doing well. And it sounds like you're saying that this is what's been happening.
Yes.
Great. Okay, so I'm just going to continue everything. Just continue to go, Miss Dixon. I mean, you got like what he's saying. If you continue at it 2 to 3 months, you'll end up with your diploma. Okay. All right. Thank you so much, Mr. Jackson. I really appreciate your help. You've been great.
No problem, Judge. You take
Okay.
care.
You too. Thank you, sir. Bye. Great. Good job. Just keep at it. Okay. So let's set it 30 days. I want to ride this through. You're so close to being through. All you got to do is see it to the end, and then everything great will happen for you here as well. Okay. All right. Good job. All right. Morning, sir.
Thank you for seeing me, Judge.
Of course.
Come before you. I don't really know what I'm doing. I just know that I came before you and I was from out of state. You tried to help me and I was kind of telling you that it was going to be dismissed anyway. I was here 9 days. They shipped me to Arkansas for 30 minutes. It was all done. Said to be dismissed on the 9th. However, the police that stopped me had my car towed and put a card in my property. And so my car was sitting there the whole time. And so I had to find my way back to Houston. Since I've been having Uber back and forth to try to, and I couldn't get my car. It was $540, now it's $1,400. They said, look, you got 4 days, sir, and we're gonna auction off your car. But then they said, if the judge you went before, if he gives you an order, we will release your car, zero balance. Again, Judge.
I can't give you an order to give you your car back. That would be me, in essence, ordering a company that does business to lose money to give you your car back because you don't want to pay to get the car back.
I don't want them to lose money. The thing is, my car was towed erroneously. I was at home. That's why I want to show you the police report. I was at
You need to
home.
file a complaint with the police, internal affairs. If you're telling me that something was done illegally, immorally, or whatnot, you need to file paperwork with that appropriate agency. But I cannot order a private company to return something to you. I don't have that kind of jurisdiction.
What do they mean you get a judge's order and we release it?
Maybe a civil judge's order. I'm a criminal court judge. The only time I can ever order any kind of property returned would be if it's confiscated by the state and they're holding it. So let's say you get arrested, you get pulled over, and you have a gun on you, right? They take your gun and they put it in the HPD property room, right? In that respect, under certain circumstances, I may be able to order them to return it because it's in the care, custody, and control of the state via HPD. Here, your car was towed by a private company and they're holding it, and it sucks. I get it that the bill has ballooned as much as it has. If you ever have a problem, you can always file a complaint with the bail bond, not the bail bond board, but there is a actual board for, there's a towing board too, isn't there?
I'm looking at it, yes.
It's a towing regulation.
There's
a request for a hearing, but I'm reading that it's gotta be before the 14th day after the vehicle was removed, is that you have to submit a tow request. The forms are all here. It's 50.
And maybe the fact that you're in custody may toll. I don't know, but I'm not versed on that kind of, and I'm number one, number two, I'm not allowed to even give legal advice, but I don't know. But I can't order them to give you your car back. You know, that would literally be me telling them, hey man, you know, just forget about all the money that you've made by holding the car. Just give the man his property back. I can't do that. I don't have the jurisdiction. Maybe a civil court under certain circumstances may order it back, but you'd have to file a lawsuit. You'd have to file some kind of paperwork.
All right, well, I'm gonna pray for a miracle.
What I would do, perhaps, can you get on a payment plan with them and say, hey, look.
Try that. They zero tolerance. I mean, honestly,
And I have to understand, because imagine how many times they've probably gotten yanked, you know?
I wish.
But theoretically, even if I were to give you a court order now, my guess would, they would hire a lawyer, file a motion to quash my order, saying that, hey, he doesn't have the proper jurisdiction to do this, right? And then they may come after you for attorney's fees. My
manager's like, hey man, if you give it to order, I'll release your car to you. He understood what happened. He said, man, just bring me something. I'll release it to you. I'm like, okay, I'm gonna go try it.
And you know, a lot of times they say stuff just to get you out, you know, but I can't. I'm sorry. But like I said, perhaps if you talk with the owner, you may be able to negotiate something with them. If you talk with if you talk with someone who has no power to negotiate, you always, if you talk to the right person, if you talk to them at the right time, you may get what you want. So don't go to them at 4:00 in the afternoon because they've been working, they're tired, they've probably dealt with a lot of people, all they want to do is go home. But go there first thing in the morning, try to get to the owner and say, hey, look, here's my circumstance, here's the proof, work with me. I want my car back. And I mean, what do you think? Anything else, Freya?
No, I'll help him out with the tow lot information, and I also have got a copy of HPD's agreement with private tow lots, so that maybe that can help him out.
Thank you, I appreciate it.
Yeah, I'm sorry. But, you never know, it doesn't hurt to try. So just keep trying it.
I'm praying for
Yeah, look.
Yes. Thank you.
Okay.
You want in the middle?
Hey, shh. All right, good morning, Mr. Cordova. Sir, you're charged with driving while intoxicated, second offense. It's a Class A misdemeanor. You're looking at up to a year in jail and or a $4,000 fine. Looks like they're going to reduce it to a first. You need to understand that it's still 2 on your record now. So after today, bless you, you ever get pulled over with the faintest smell of alcohol, dope, whatever it may be, what do you think's gonna happen? What's gonna happen? Not with me. From now on, you've now graduated to felony court. 2 and 2 make 3. A third DWI, you're looking at a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. And I'm going to tell you that you don't have to be falling down piss-ass drunk where you urinated and puke everywhere. Just the faintest smell of alcohol, they're going to look your record. They're going to assume if it walks like a duck and it talks like a duck, they're going to just rather take you off the street. They're not going to try to be cool and let you go. What happens if you kill a family of 5? That officer's career down the toilet. So in an effort to make sure that doesn't happen, they're just going to take you off the street. And you thought now was bad. Wait till you get to felony court. All you have to do is don't get into a car, even if you've had a sip. One button on a phone, $30 will take you wherever you want to go in this life. Don't matter where you want to go. How much money have you spent? I want you to know that you are now skirting, by doing this probation here, the mandatory 5 days in jail that you would normally be having to do. But I want you to understand that I'm going to hold you to this probation. Shh. And if you fail to do what you're supposed to do, I'm telling you now, I'm going to lock you up. And if I find that you have a problem with dope, you have a problem with alcohol, I can and will most probably put you in a rehab facility in the jail. Do you understand? No alcohol means no alcohol from any source, no matter how long, whether you're a month away from completing probation, whether you're 1 week. I can't tell you how many times people get back here because they say, oh man, I've got a month left on probation. I've got 2 weeks. They're not going to do anything. Boom, you get tested on the last week of probation. So get ready. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take this off. You understand? This is what you want to do. How do you plead to the offense of driving while intoxicated? Guilty or not guilty? I will find you guilty and I'm going to sentence you to 180 days in jail. I will probate that for 12 months. As part of the probation for you to successfully complete it, you must do a repeat offender DWI education class. You must do 1 victim impact panel, a TRAS, which is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill that. It could be intensive outpatient treatment. It could be supportive outpatient treatment. It may be something else. If they assess something further, you must complete it. No drugs, alcohol, random urinalysis, guardian interlock, no breath test refusal. If you were pulled over in a car and an officer asks you to submit to a breath test, you must do it while you're on this probation.
Your Honor, if I may, Mr. Cordova has a scram and he'd like to keep that because he has hired a driver. We know it's a first DWI, but DPS, sometimes they may come back and do a hard suspension or 90-day, and we don't want any missteps. So he's okay with that if the court is.
Problem is, I've been paying it for you now. I can't pay for it anymore. You're going to be responsible for this thing on your own now. That thing right there is $500 a month that I've been eating, so you don't have to pay for it. So I don't know how your finances are, but an interlock is typically, what, $100 a month? I don't know, but that, it's at least double, if not more, than what an interlock costs.
Can you afford that?
That's fine. I can't pay for it. I don't, while he's on probation, I can't pay for things.
And that's just my concern. If he gets the breathalyzer, he's not driving, then it's going to be a violation because he's not driving.
We do portable devices.
We tried that, Judge. I don't trust those. I've had a lot of, I think he feels the same.
No,
There's been so many issues. with
It's up to you. I'm happy, whatever you do, just make sure you maintain compliance. Don't stop charging it. Don't stop paying for it, because at that point, all we're gonna end up doing is issuing a warrant for your arrest. $100 donation to the Houston Food Bank and a 30 hours of community service. Give children. How many kids you got? I'd rather, instead of the community service, do a parenting class. I think
Right,
people
sure.
would be better served with doing a parenting class than just mindless
I think that's very.
dumbass work on the street. Forget about it. No, you're better served learning things in this life than to just do menial work. The idea is that you learn so that you don't come back and that you don't graduate to felony status, because then I'll tell you what, this is going to be hard on you. But when you end up with a felony on your record, it closes so many doors. It's unreal. You lose the right to vote. You want social services from the state. Forget about it. Not when you're a convicted felon. It just closes so many doors. So you need to do everything in your power to prevent that from happening. How do you plead to this? You said guilty? How do you plead? All right, I'll find you guilty. I'll send you to this agreement. One more thing is there are fines and fees that you're going to be required to pay. There's a supervisory fee that you're going to be required to pay for this DWI. It's a $6,000 fee. We will give you time to pay it. I give him 2 years.
We did discuss, he makes a good salary, but he's got 5 children. So I don't know if the court would consider waiving that or.
So what we typically do is we give him 2+ years to pay it, and it ends up being like $100 a month. Just don't stop paying it, What I'll do is I'll waive the court costs.
Fabulous thing.
Okay, so that'll take off like $500, but
Right.
you'll have to pay the supervisory fee. It's a lot, but we'll give you time to pay it, and don't stop, because if you stop, we will issue a warrant, and your butt's going to sit $100 for every 1 day for every $100 you owe. Hopefully this is enough to get your attention, because at the end of the day, you're walking out of here when you should be doing jail time.
Right.
So it's going to cost you a pretty penny, but hopefully that's enough to get your attention. You understand?
Sure.
Okay, man. Good luck.
Thank you,
Thanks.
appreciate you.
Sure. Yeah, I have to suspend the license.
No, and that's.
I'll do it for a year, and then, show me that you're good. I'll entertain an occupational later on if he's doing well and in compliance with the probation.
Sounds good. Thank you.
6,000.
Morning.
Hi.
Morning, Judge. I'm here on Ricardo Vargas, Narcissus, Narces.
Is it under Vargas? Yes, I see it. Yeah. Okay. What would you like to do?
Thank you, Judge. We're asking to roll this till Monday. My client's getting his interlock literally right now in his appointment. The supervision order's already been submitted by the state, I believe. She just told me that a few seconds ago.
Can I sign it, or you want me to wait, Morgan, since he doesn't have the interlock yet? Yeah, I think that we're talking about Vargas. He's getting his interlock today, but you guys, did you submit a PTI order already?
I was told to
Hold it, right?
delete that and hold it till Monday.
Yeah, okay.
because we need proof
Then,
of that.
yeah, we'll do that. All right.
And that's all we plan to do. We'll have it ready, Judge. Thank you. I appreciate that.
Morning, Judge. I'm approaching on a bond violation for Mr. Lazo Morphine, Lazo. He's here in the translator is here, Judge.
Okay. Lori, why are you still here? Just go. I'll call you if he shows. I mean, it's 11:45. What's the last name? Oh, I'll call you if he shows. Why are you here?
Tengo corte hoy.
I have court today.
No kidding.
De veras.
You don't say. ¿Por qué también estás aquí, señor Lazo?
Nomás porque tengo corte.
Just because I have court.
You have a bond violation.
Violación de su fianza.
They are telling me that you are tampering with your scram device.
El grillete.
Specifically, at 1 a.m. on
de la mañana,
October 15th.
el 15 de
Judge,
octubre.
with that,
Pues con
there's not very much
eso no hay
information
mucha
listed on that PR. I
información.
looked further into it. The tamper lasted a duration of 25 hours and
Duró
51
25 horas y
minutes,
51
and alcohol was
minutos y
detected,
alcohol fue
but could not
detectado,
be
pero no
confirmed
se pudo ser
on that
confirmado.
tamper as well.
Ese caso de manipulación también.
What they're telling me is that you tampered with the device for about 25 hours
5 horas.
and alcohol was detected during that time.
Yo ni siquiera he movido el aparato y alcohol no he tomado nada.
I haven't even moved
No,
the
drink
device and
No, they're
I
telling me.
didn't drink any alcohol. Eso no es lo que me está indicando.
Sí, pero yo no he tomado nada,
I
nada que
haven't
he
drank
tomado.
anything.
Nada.
Nothing.
Y esto ni,
They're telling me.
Eso
ni
no es
lo he
que me están
movido.
diciendo. I haven't
No lo he
moved it.
movido
I
nada.
haven't moved it or anything.
That's not what they're telling me.
Eso no es lo que ellos me están
Pues
indicando.
no sé cómo, pero si yo no lo
I
he
don't know how I
movido.
haven't moved it.
Y ni he tomado
I
nada.
haven't
Nada.
drank or anything.
Nada.
I unfortunately don't know how you tamper
¿Cómo
with the
fue
device, Mr. Lazo.
manipulado?
But from what I understand,
Pero por lo que
I want you
entiendo,
to listen.
quiero que escuche.
You have somehow
De alguna
tampered
manera
with the device.
ha
The
interferido
device is supposed to maintain a constant contact with your skin.
con su piel.
And the device lost contact with your skin for 25 hours.
Pues no.
Not only
I don't know why.
did it lose
No
contact, but during that duration,
De ese
they also
también
tested alcohol.
resultó en detectó alcohol.
No he tomado alcohol, no sé por qué dice que alcohol, no he tomado nada. Desde que él me dijo que no tomara, no he
Since you
tomado
told
nada.
me I haven't, since
No
you told me
tomo
not to,
nada.
I haven't drank anything. I don't know why.
You got?
¿Qué tiene usted?
Well, Judge,
Bueno, pues,
I mean, this is my client's word
la palabra de mi cliente
versus
en
technology.
contra de la tecnología.
Being that it's an imperfect world, I
Es un
would
mundo
request the
imperfecto
court
de pedir
admonish
que la
him
corte lo
and
amoneste
make sure he gets
y
the
que se
problem fixed.
asegure de que entienda.
Sorry, Mr. Lazo. You tampered with the device for 25 hours. What am I supposed to do? Just let you go?
¿Qué es lo que debería hacer? ¿Dejarlo ir?
No sé por qué, digo que siempre lo traigo igual, lo traigo donde
I don't
mismo.
know.
Y
I have
anda la
it
piel
the same
ahí.
every time. That's my skin.
Sí.
Judge, this is a second
Pues este
DWI,
es un
close to
segundo
two-car
caso
accident. I think you should go
identificado
zero
con
tolerance.
Yeah,
accidente. Pienso
I
que
agree.
debería ser otra
Taking you in.
sí.
I'm sorry.
Entrar, lo siento.
The bond is set now at,
Entonces la ponemos entonces ahora
it's at $100. I'll set it at 5,001.
a 5,001.
Mr. Lazo, I need you to understand that we mean business. You can't tamper with the device for 25 hours. And they detect alcohol and think that good things are going to happen.
Si no es eso, buenas cosas hubieran sucedido.
No alcohol, nada, nunca. Y esto
Nothing,
siempre anda
no
igual.
alcohol. It's always the
No lo he
same.
movido.
The device tells me differently.
El aparato me está informando.
Goes with you.
Yo respeto.
I respect the things that you told me.
We'll talk. Please.
You need someone from the state?
Stay, please. You are Carlos Gomez.
Yes, sir.
Shh. Mr. Gomez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 180 days in jail to be probated for 12 months. Is this a second being reduced to a first? Is it a true first?
No, Judge, so he had a prior DWI that was dismissed via our PTI program.
Okay, so repeat offender then. Okay, the reason I'm asking you is because, or the reason I'm asking is because we have different types of education programs. You already did one education program and that didn't take. So now we have to do the repeat offender DWI education class in hopes that that one works, because you pick up another one. From now on, you will be facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. Do you understand? You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, this will go on your record. It's going to be there for the rest of your life. What do you think an officer is going to do if they come up to your car, they see DWI dismissed, DWI conviction, and then they smell alcohol? What do you think they're going to do? Sorry?
They'd take me.
I would venture a guess, no questions asked. Don't matter if it's just even the faintest smell of alcohol, faintest smell of weed, anything funky in your car, they smell it, they're going to take you down, because all they look at, your priors and what you smell like. That, two and two together, that's all they look at. Do you understand?
Sure.
So I would never, even if you had just a sip of alcohol, I wouldn't get into a car, because it's a huge and it's a humongous financial gamble. Do you understand?
Sure.
As part of this agreement, you will do, like I said, the repeat offender DWI education class, one victim impact panel. You will also do a TRAS, which is an evaluation to see what other conditions you may need. If they assess other conditions like intensive outpatient treatment, supportive outpatient treatment program, you must fulfill those additional things. Substance abuse treatment, no drugs, no alcohol, random urinalysis, no breath test refusal. So if you're pulled over in a car and an officer asks you to submit to a breath sample, you must take it. Guardian interlock, 23 hours of community service, and a $100 one-time donation to the Houston Food Bank. This is how you understand the agreement.
Sure.
If you fail to live up to your side of the bargain, you test positive for alcohol, don't do your classes on time. If you pick up a new case, if you drive on a suspended license, we will issue a warrant for your arrest. I'm going to put you in jail. I'm going to roll you back out here in orange. We're going to discuss whether you violated your probation. If you did, you're looking at 180 days in jail. Do you understand?
Yes, sir. I understand.
You still want to do this? Okay, how do you plead to the offense? Guilty or not guilty?
Okay.
I'll find you guilty. I will follow the agreement, send you to it. Max, about the fines and fees and surcharges, what do you do for a living, sir?
Driving.
What kind of money do you make? You have a CDL?
Yes, I got CDL. Right.
You realize that the CDL is now going to be suspended. You realize that a second DWI conviction, you'll lose that CDL for life. Do you realize that? Yeah, a second DWI conviction, you'll lose the CDL for a life. When you are a CDL driver, you are held to a higher standard. The entire world is at a 0.08 legally, right? For what they consider intoxication. When you have a CDL, it's even lower. It's at a 0.04 or 0.05. You are held to a higher standard because you were supposed to be better, do better because of that CDL. You will be required to pay the supervisory fees. And I want you to understand that if you don't pay it, you will go to jail. Every $100 that you owe is 1 day in jail that you will do. So we have to get through to you somehow. I hope that this is it. But you got to understand that on our streets, every single day, someone dies from a DWI. And it's truly a pathetic and sad thing. That's what we are trying to prevent. And I hope that this is the last time.
Yeah.
Do you understand? Because if not, we have a jail just waiting for you. All right. Good luck, sir. All right. So 3,000 and then whatever the court costs are and then 2 years.
$0.228.
I don't have the paper here.
This was the one we were emailing. He was on for today. And then,
Yes, she put it on for tomorrow and then I guess I sent an email to keep it on for today. And I guess I never got it.
You have the case number?
No, do you mind?
252-8814.
That trial case we had, Judge, where we came to that global resolution with Fort Bend's DWI court.
And now you have bond violations. You have an open DWI here. You have an open DWI in Fort Bend. And now you have bond violations.
Judge, I think we can explain. Yeah. Judge, he works for Mattel, the toy company, and his shift was starting at 9 o'clock and the company changed it. It sounds like quickly changed it to 6:30 a.m. Takes him about 45 minutes to get there. I have his logs where he's logged in showing 6:30. His granddad is driving him to work. It takes about 45 minutes. My understanding is he communicated with pretrial about the need to get to work or that he went to work. And hopefully it would, if we had the GPS data, it would show that he went from his home to his place of work straight.
Any other violations?
No, Judge.
So what are the timing violations?
It was an unapproved leave, so he left early at 5:41 in the morning, and his curfew is at 6, or he's allowed to leave at 6.
Okay, that's it?
Yes, Judge.
Okay, I'm not gonna ding you on that. Just,
We would like to ask you to consider making it from 6 a.m. to 5:30 a.m. Would that allow you to get to work by 6:30?
yes, I'm okay with that, Troy. I mean, if it's just a matter of trying to get to work and that's the nature of the violation, I get it. But come to us first. If they change your duties at work, if they change your time at work, you got to come and let us know so that we can change it for you. Don't just start doing things on your own because then things go haywire. You have to answer up. So I'm okay with you going to work. I'm okay if you need more time, but ask, okay? And you want 5:30 in the morning?
Yes, Judge.
Okay, you got it.
And so we thought the setting in Fort Bend was yesterday. We thought it was going to be on 12/4. It's on 12/20. He's supposed to be entering into a DWI program. It looks like there's some steps I'm trying to keep up with.
And it's to set it the day after that day or the couple days after?
Beginning of the year. I mean, do you have I don't mind coming back if you have dockets.
Yeah, we don't go anywhere. We're here, so I would like to hopefully end this before the end of the year. That way he's in the program throughout the holidays. That way there's no temptation, throughout that time. So what day in Fort Bend do you have court?
December 20th.
December 20th. Okay, so why don't we set it, that's that Friday. So if you want to set it the next week, any day. Not Monday though, because I'm going to be gone that Monday, but any other day other than that Monday, I'm okay with. Yeah. Okay. All right.
And any chance he can drive, Judge? He has the interlock device, right?
Yes, I have one.
I'm not. No. Don't push your luck. You have 2 open DWIs. I'm not letting you drive. No, you scare me, dude. No. And it's nearing the holidays. Get in the program and then we're done here. Right? You're off mine. I think this case gets dismissed, right?
Yes, sir.
Once this case gets dismissed, you're under no more of my jurisdiction. You can do whatever you want, right? So it's an incentive to get you to work this thing, to get this thing done once and for all. I mean, you're literally in the home stretch, right? You got what? About 2 weeks, you're in.
All right.
Do what you need to do, get in. All right?
Yes, sir.
Okay, guys, good luck. Can you see whether he's given a PR bond? I know, he just bonded out, that's why. But we need to do conditions, that's why. But I want to know whether he bonded out or they give him a PR bond, because I don't see it. It's not.
It was a surety bond.
It was, okay.
Let me look at the other one.
Is this a situation?
It was surety bond on both of them.
Okay. Mr. Tujakas, I hope that you understand that we mean business. I will protect every person of Harris County. I don't care who you are. I don't care what color you are. I don't care what gender you are. I don't care if you're a small farm animal. I will protect every single person. You don't put your hands on anyone. And if you pick up a third case, I'm going to do la cucaracha on all of your bonds. Do you understand? I'm going to go absolutely bonkers on your bonds if you pick up a third case. You are not to have any contact with any of the complaining witnesses in these cases. You're not to consume alcohol, illegal drugs. You're not to be in possession of any weapons. Anything else, State?
You said no alcohol, no drugs, no weapons. We would also say no contact with the complainant,
Yeah.
Judge.
I think that goes without saying.
Restriction.
So we did a,
He lives there.
we removed the residential restriction yesterday, the residential restriction, because council said that he lived at that address, but I need to make sure now that he's out, that she's not living there. Do you have? Oh, she's in custody. That's right. That's right. She's in jail. Okay, so no, I'm going to leave it as, so the complaining witness is in custody here with us because she has an open PCS out of Travis County. And I don't, do you still have the cause number on that one? Is there a bond that's?
Number yet, it's bond denied, so
It's bond denied. Okay, so it's bond denied, so she can't get out until that 10th day hits, at which point we will set a bond and then go from there. So you know now what's expected of you. Don't mess up. Do you understand? You must also remain in contact with your lawyers. If your lawyers tell me that they can't get a hold of you because you're playing games and you're not responding to phone calls, text messages, likewise, I will issue a warrant for your arrest. I'm not asking for much. I just want my county protected. That's it. And I'm going to do it at all costs. Do you understand? Okay. All right.
Thank you.
Got it. So he's going to be monitored through pretrial, just for no alcohol, no dope. Good morning, Mr. Egan. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On November 28th, 2024, officers conducted a traffic stop on defendant's motor vehicle after observing it pass him at a high rate of speed, make multiple lane changes, and swerve in and around cars in a reckless manner. Officer accelerated to catch up to defendant and reached speeds of over 100 miles per hour to keep up with him. The defendant traveled about 7 miles in about 4 minutes. Upon contact with the defendant, officer observed glassy eyes, a strong odor of alcoholic beverage, an open beer can in the center console, a 6-pack of beer in the passenger seat, and spilt beer that was still cool to the touch in the front passenger seat.
Drinking while driving?
Yes, Judge. The defendant admitted to drinking. SFSTs were conducted, 4 out of 6 HGN, 6 out of 8 walk and turn, 2 out of 4 one-leg stand. DICs were read and consented to. The defendant blew a .147 and a .139. He does have an eligible driver's license, Judge.
Can you look to CPS and you prior DWIs, please?
He had a DWI out of Travis County, but he was released without prosecution, Judge. So it's just a charge.
2 things. I am ordering you not to drive at all. You will be signing an affidavit with me today, Mr. Egan, This is a promise that you're going to make to me that you're not going to drive. I don't give a rat's behind what your excuse is. I don't care if Mother Teresa needs to ride to church. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive because it's an offense in and of itself. Do you understand? I'm also now ordering you to obtain a handheld interlock device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. At the next time, if I find that you violate conditions, I will revoke your bond, put you in jail. You will not get any more PR bonds. Do you understand me? We are sending a court order to DPS in Austin so that every single officer in this state will know that if you are pulled over, any car that you're to drive must have an ignition interlock on it. I'm ordering you not to drive at all. But if at some point you do, by some miracle, get the ability to drive, I'm ordering you not to drive any vehicle that doesn't have an ignition interlock on it. So if you're caught driving a vehicle and it doesn't have an interlock on it, you will go to jail. Do you understand? And then if I find that you drive, we can have a contempt hearing. So just don't drive and don't use alcohol. Do you understand? Or illegal drugs. We are going to reset your case to give you time to hire a lawyer. So I will have you come up here, swear to us that you're not going to drive. I'll get you to Ramona Senate.
No, sir. You're still talking. Sorry.
I will get you to Ramona sign a reset. You will then get with Felicia for your bond conditions, and after that, we'll let you go. Don't pick up any new cases. Behave yourself, because I'm going to tell you now, Mr. Egan, I will do everything in my power to protect my streets. And if that means locking you up and putting your bond in a sky-high amount, I'll do it in a heartbeat. Do you understand? All right.
Our next one is gonna be, Ms. Sanchez on 21. Yes.
Good morning, Ms. Sanchez. Ma'am, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Defendant were in a dating relationship for 5 years. On November 27th, 2024, officers were dispatched to a residential home in Harris County, Texas, in reference to a family assault in progress. The officer contacted the complainant on the phone and could hear him screaming in pain, telling the defendant to get off of him and to stop pulling his hair. Officer asked the complainant if the defendant was still assaulting him, and the complainant responded yes. Defendant fled the scene on foot when officers arrived. The complainant gave the direction of travel to the officer. The complainant stated he and the defendant had been putting up Christmas lights after drinking, and an argument ensued. The complainant said the defendant began attacking him by pulling his hair, causing pain. The complainant fell to the ground and the defendant proceeded with kicking him. The complainant said that when the defendant drinks, she gets aggressive and wants to fight. Officers returned the defendant to scene and she would not cooperate, was yelling obscenities at the complainant, and was acting belligerently.
Okay. Ms. Sanchez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol or illegal drugs, and I will randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. You will not get any more PR bonds. Do you understand?
Yes, sir.
If you don't have anyone to pony up $5,000 to $10,000 on the bond for you, guess what happens? You'll be stuck like Chuck until this case is over with. And I'm going to tell you, it takes damn near 9 months just to get a 911 tape. Behave while you're out there in the free world, or I will take the free world away from you.
Absolutely. Yes, sir.
Tell me, what do you do for a living?
I'm a recruiter, skilled trades, and then operations coordinator.
You have an income.
Not at this moment. I recently got laid off in October.
Okay. I have an application already on file. Do you want a court-appointed lawyer, ma'am?
At this time, yes, sir, if you could, please.
We need to talk about the complaining witness.
So Conrad has spoken to the complainant and he would like no contact as well as a residency restriction, Judge.
Okay. You heard that, Ms. Sanchez. There's a protective order that has been issued in this case. The protective order was issued on November 28th. I would suggest you get to know it. If you violate the protective order, they can and will file a violation of a protective order against you, and that is the capital murder of misdemeanors. It's one of the worst cases you could pick up over here.
Oh, yes,
You
sir.
understand? So
Yes, sir.
don't have any contact with them,
That's not a problem, sir.
be in possession of weapons, and don't go back to the house listed on the protective order, which is at the Woodlands West.
That is not a problem, sir.
Okay, so I'm gonna have you sign a receipt with Ramona. We'll have you get with Fleischer for your bond conditions, and then we'll have you take a seat in the jury box. We'll find you a lawyer, please. Do you mind filing no contact and no weapons, please?
Yes, Judge. And did you also say no alcohol or?
Oh, you know, what? Don't worry about it, because since she's monitored, don't even worry about it. Right.
All right, Sir Tucci on page 22. SER. Did I pronounce it
Sign
close?
it?
Yes, I did. Okay.
Give me a second. Let me see.
Connor.
Morning, sir.
Judge, does Ms. Sanchez have any documents to sign? With me.
Yeah, she will with Felicia. She's getting monitored.
Okay.
Yeah. Um, All right, so you are Justin Sertucci.
Sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On November 27th of 2024, officers were dispatched to a person down call at the intersection of Bagby and Elgin Street. Officers observed the defendant's motor vehicle stopped in a moving lane of traffic. HFD advised that when they arrived earlier, the defendant was in the driver's seat behind the wheel with his foot on the brake and the vehicle in drive. HFD EMT further advised that when the driver woke up, he admitted to having been drinking. Officers observed a strong odor of alcoholic beverage and glassy eyes on the defendant. SFSTs were conducted, 6 out of 6 HGN, 8 out of 8 walk and turn, 4 out of 4 one-leg stand. On the way to JPC, the defendant threw up in the patrol vehicle. DICs were read but refused, and a search warrant for blood was signed and executed. He does have an eligible driver's license, Judge. He doesn't have any prior DWIs, but he has juvenile history.
Okay. Mr. Sertucci, I'm going to find that there's probable cause to go forward with the case. Do you have valid liability insurance in your name? You have car insurance?
Sir.
All right, I am ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, your bond will be revoked. You will go to jail. No more PR bonds. You understand?
Sir.
I see that you have a lawyer. Because you have a lawyer, we will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. Saman. He'll tell you when you have to come back to court. For now, I'll have you sign a receipt with Ramona. We'll have you get with your bond conditions with Felicia, and then we'll have you take a seat in the back, wait for Mr. Omar. All right? Please.
One last one, Your Honor. I skipped her by accident, page 3,
It's okay.
Blackburn.
Is it Chaston?
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 Yes,
Ms.
sir.
Blackburn, you're charged with driving while intoxicated. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing up to a year and or a $4,000 fine. And on the DWI, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you cannot afford a lawyer will be appointed to represent you, ma'am. Okay.
Officers were conducting an unrelated fatal accident investigation when they observed the defendant's vehicle traveling at a high rate of speed toward the blocked portion of the roadway. Officers saw the defendant disregard a barricade and were able to successfully get the defendant to stop by shouting verbal commands and utilizing their flashlights. Upon contact, officers observed a moderate odor of alcoholic beverage, glassy, watery, bloodshot eyes, and slurred speech. The defendant admitted to having 3 drinks at a nearby bar and was temporarily detained. SFSTs were conducted, 4 out of 6 HGN, 4 out of 8 walk and turn, and 2 out of 4 one-leg stand. DICs were read and breath was consented to. The defendant blew a .086 and a .084. During search of the vehicle, officers located a handgun within the center console. She doesn't have any priors, Judge, and she does have an eligible driver's license.
All right, Ms. Blackburn, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or drugs, you will go to jail. You will not get any more PR bonds. Do you understand?
Yes.
Do you have a lawyer, ma'am? Tell me, what do you do for a living?
I've been staying at her mom since I was 21. I just part-time job at HEB 2 days a week.
Okay, what, so you're married?
Married.
What does your husband do for a living?
We're in real estate.
Okay, do you have the ability to hire a lawyer?
No. I'll have to speak to him. He can try.
So what we'll do is I can give you time.
Okay.
You know, what we normally do is we reset cases for 30 days to give you time to go hire a lawyer. But this is a DWI and there's a lot of timing requirements with the DWI. So don't just sit and wait a month or 2 months because you're only hurting yourself. You need to get on it. You need to get on it quick. Okay. If you have any issues, you can come back and tell us and then we can go from there. Okay. For now, I'll have you go to Ramona, sign a reset. We'll get with Felicia for your bond conditions, and after that, you'll be free to go. All right? Thanks.
Today's docket ran long and covered more ground than most, and a few cases are worth slowing down for before we close it out. A father stood before the judge on a charge of making a firearm accessible to a child. His son found the gun on a bed and accidentally shot and killed his 10-year-old brother. The case is 200 days old. The family is still together. The surviving children are in therapy. The judge asked to read the letter first. He said, "I want to know if you are truly remorseful or if this is just words on paper." Then he said something that cut through everything else in the room. "Is the fact that your own child is dead because of this? Is that punishment enough?" He answered his own question quietly. He said, "There has to be some." A man was caught underneath a car in an apartment complex cutting a catalytic converter while a second defendant sat in the getaway vehicle. The judge looked at the record, revoked his bond on the existing case, and said, "Each one of those is worth $5,000 to $6,000. Life is hard enough as it is." The revocation was immediate. A 27-year-old walked into court without a job, without a plan, and without a straight answer about how he supports himself. He told the judge he had been out of work for 2 to 3 years. The judge asked, "How is it fair that the people of Harris County have to foot your legal bill when you get to play Xbox all day and do nothing?" He gave him a lawyer anyway, and made it a condition of his bond to get a job. 2 weeks. Come back with something in your hand. If you don't, it will not go well. A man drove through a police barricade at a fatal accident scene. Officers working the scene flagged him down with flashlights and verbal commands. He blew 0.086 and 0.084. Officers found a loaded handgun in the center console. 2 charges. DWI and unlawful carrying. No prior record. The judge gave her 30 days to hire her own attorney and warned her, on a DWI, the timing requirements are serious. Do not sit on this. A man who came to a bar was asked to leave, got in his car, and then came back carrying a gun. Threw the weapon under a fence when security approached, had the bullets removed by the security guard, and was handed the gun back. Then he hopped the fence to get back inside. The judge ordered him not to return to the bar, not to possess any weapons, and told him plainly, 2 to 3 years without a job is not a plan. It is a problem. A man on his first DWI had his car seized. A vehicle the judge estimated at $90,000. He waived every fine and fee because the forfeiture had already taken everything. He said, "Someone is going to benefit very nicely from that." Actions have consequences. That is a lesson that costs more than most people in this building will ever pay for a mistake. And a man pushed his girlfriend to the ground, stepped on her neck while she was still down, and had already picked up a prior assault before this one, and a felony evading arrest after it. 3 cases. The judge worked through the probable cause on each one methodically, making sure nothing was missed before setting conditions. This courthouse handled grief and negligence and catalytic converters and a gun thrown over a fence and a $90,000 car driven into a forfeiture, all before noon. We will see you in the next one.